My name is Grant Seabourne, and I'm a certified financial planner with First Financial Trust.
My name is Tori Barrett, and I'm a trust relationship manager here at First Financial.
So, Tori, the first question I was going to ask you, oftentimes the first step in any estate plan is to draft your will. So can you talk about some of the common things that you may want to think about when you're going through that process?
Yeah, definitely. So a will or a last will and testament is kind of the baseline of an estate plan. And it starts off with delineating specific gifts, specific requests that you have for specific individuals, making sure that those requests are being carried out upon your passing. It's a really important task, and that task is handled by the executor of your will. And so when we're thinking about somebody to appoint as executor, some recommendations would be someone that is trustworthy, somebody that is capable of handling the nuances and the legalities of an estate, and then also somebody who would act in your best interest and carry out your wishes in your will. So those are some things to think about as you're appointing potentially an individual or a corporate executor for your will.
That's a great point. What about for parents who have minor children? Is there anything in the will that you need to be aware of?
Yes, for parents of young children specifically, you can appoint a guardian for your minor children within the terms of the will. And I think that that's a wonderful strategy to make sure that your children are taken care of after your untimely passing.
Yeah, that's great feedback. Everybody needs a will. You don't have to be elderly to require a will.
That's right.
Yeah. When you're meeting with an attorney, you need to ask about the last will and testament. Are there any other estate planning documents that you may need to inquire about?
Definitely. That's a great question. I think that a durable power of attorney and a medical power of attorney are two very important documents. Those come into play at the point of your incapacity, and they terminate at your end of your life. And then a living will provides a directive for how you want those end of life decisions to be made. So it'll come in, at those very critical moments, and it will terminate the same way that the powers of attorney do at the point of passing. And it really just creates a holistic approach to the estate plan to where we know where all of your assets are going and all of your valuables and family heirlooms, things like that. But as it relates to the individual themselves, it kind of takes the onus of making those critical decisions for healthcare and financial decisions off of your loved ones and creates a plan for them to just follow at the point that it's needed.
That's great, Tori. Yeah, it's a lot about peace of mind, ensuring whether incapacity or at your passing, that things are carried out according to your wishes in the way that you would have done it with appointing trusted agents and executors.
That's right.
So, Tori, we've talked about the last will and testament. Another very common estate planning strategy that we see implemented is the revocable living trust. Many people come in and ask, I think I need a trust, or why would I need a trust? The RLT is a very common one that's implemented. Can you talk a little bit about why you would set up a revocable living trust, what it accomplishes for you?
Definitely. A revocable living trust is established during the trustor or the grantor's lifetime, and it exists in perpetuity until the termination point. And pretty much the main reason that somebody would choose to have a revocable living trust is to avoid probate. Probate is a very time-consuming process, and it can be a very costly process. There's also some holdbacks as it relates to the timing of distributions and gifts that are being made from an estate. So there are some advantages of having a revocable living trust that you can administer throughout your lifetime at the point of incapacity and then after your death as well.
Yeah, so not only do you avoid all of the horror stories that you hear about how long an estate administration can drag out, you avoid the time and expense of that. But yeah, talk about if someone were to lose their mental capacity, how does a revocable trust come into play in that scenario?
It's a great tool to have because you've already made your plan. You've already laid the groundwork for the trustee to step in and say, these are the parameters for the distributions that I'd like to make. These are the specific bequests that I'd like to make. This is how I prefer for things to be handled as it relates to oil and gas, as it relates to real estate, as it relates to personal property. All of those things can be accomplished by the revocable living trust, and it it can really give the grantor peace of mind in knowing that their wishes will be carried out throughout their incapacity and after their point of passing.
Absolutely. You retain full control while you have mental capacity and while you're living, but then if you lose capacity, a successor steps in behind you, a successor trustee, to continue managing your assets for your benefit. Yeah.
Yes.
Yeah.
And I
great.
think that would be another instance where a corporate trustee would be a great person to nominate as a successor trustee in that regard.
Very good point. You have to have investment expertise, investment management expertise, experience in taxes, fiduciary skills. So corporate trustee is oftentimes something good to consider.
Right.
I agree. And, as we've talked about before, some estate planning tactics can be beneficial from an estate planning, from an estate tax standpoint, but you can lose the step up in cost basis. Whereas with the revocable living trust, you retain control and you still benefit from the step up in basis that you're passing. That's another thing that I think is a good benefit of the RLT.
That's a great point, Grant.
Thank you, Tori. So, Tori, we've talked about the last will and testament. We've talked about revocable living trusts. Let's talk briefly about another type of trust. Let's say that you're a parent or a grandparent and you're working through your estate plan, and you may have children or grandchildren who would inherit a substantial amount from you, and they may not be necessarily capable of managing those investments or those assets. Can you talk about a very simple technique that you can establish through your will to ensure that your assets are custodied for the benefit of your children, but managed by either another individual or a corporate trustee?
Great question. I think those circumstances would really require a testamentary trust, where you're kind of letting the corporate executor or the person that you've appointed as trustee to make those decisions that are kind of outside the wheelhouse of the beneficiaries. And they're able to make those investment management decisions as well as discretionary distribution decisions with the information provided by the committee, the internal trust committee, and the parameters set forth in the document itself. And so it's another way for the grantor to kind of have that assurance that their wishes are going to be carried out after their point of passing, and knowing that their children or their grandchildren, like you mentioned, would have kind of that expertise that they lack in order to maintain those gifts and to grow, transfer, and protect wealth.
Yeah. And like the revocable living trust, it doesn't negatively affect your ability to receive the step up in cost basis. So if you have significant gains in your estate, the assets that flow through your will into the trust have received the step up in basis. And it's not a complex document that you have to draft now and give up control. You continue to retain control over your property. When you pass, your property flows through the will into the trust. So it's very much an agreement that's strapped within your will.
Right. That's the beauty of it. It's all constructed under that one document, and the parameters are set forth very clearly within the will. So it's very easy to pick up administration.
And is there a specific age at which these trusts have to terminate, or how much flexibility does the grantor of the trust have in drafting the provisions of those documents? Is there flexibility?
I would say full control, full flexibility. And it really comes down to a determination of kind of the maturity level, the ability to manage significant amounts of money, life circumstances of the beneficiaries, depending on their taxable income, their tax brackets, and just kind of the nature of the gift that they'd be receiving. A lot of times we see 25, a lot of times we see 35. It really, an age is to some people just a number, and it really is on a case-by-case basis determined on what the grantor deems to be an appropriate age for the trust to terminate for the specific beneficiaries.
Yeah, absolutely. Well, I'm sure a good topic to discuss with a qualified attorney as you work through your estate plan.
Absolutely. Yeah. Definitely a question for your attorney.
Our next question is a little bit different. So as we move, most of our discussion so far, we've talked about the last will and testament, revocable living trusts, testamentary trusts. None of those really accomplish the goal of reducing estate tax or reducing the size of your taxable estate for estate tax purposes. So can you talk a little bit about the type of trust that you would establish now, today, to help in the endeavor of reducing the size of your taxable estate for estate tax purposes.
Definitely. So if the main goal is reducing your taxable estate, we would recommend an irrevocable trust. So that's one that is funded throughout your lifetime. You put assets into it, money, assets. You change the title over to it. It has its own EIN. So it kind of operates functionally like another human being. And it has the effect, the irrevocable trust has the effect of divesting the grantor or the trustor of their assets to where those now belong to the trust itself. And so that's a very effective way of reducing a taxable estate for the grantor.
Yeah, that's a great point. And we should have led with the fact that there's a lifetime exemption amount that is excluded from estate tax. If you, as an individual, if you own less than $15 million in assets for the year 2026, then that is under the threshold for a taxable estate. So a married couple, that would be 30 million. So this would be a strategy, a trust that you establish today, as you said, start funding to exclude future growth on those investments from being taxed at the estate tax level.
Right.
Yes.
It can be advantageous for individuals or, like you said, married couples to do a joint gift.
Yes. I think importantly to note, once you have funded this trust, it does help shelter that future growth from estate tax, but you do, unlike the revocable living trust or the testamentary trust, you do lose that step up in cost basis. Mm-hmm. So something to be cognizant of. If you have assets with significant gains, those will continue to be taxed at capital gains rates over the course of the life of the trust.
That's right.
So, Tori, so far we've talked about revocable living trusts, last will and testament, testamentary trusts, and irrevocable trusts. There was a very commonly used strategy, quite a few years ago, that was the bypass trust. And the purpose of that trust was to shelter additional assets from estate tax. If you had assets in excess of the lifetime exemption, which for 2026 is 15 million for an individual or 30 million for a married couple. Can you talk a little bit about why bypass trusts are less common now than they used to be?
Sure thing. So post 2011, the landscape for estate planning has kind of shifted. It's shifted towards this portability language. That's the buzzword that we hear. And the big point with the portability election is that instead of using the traditional bypass trust route, we're just electing on Form 706 the portability election to allow the deceased spouse unused exemption amount to flow over to the living spouse. And so they kind of collect that advantage that originally had to be drafted for within the means of a bypass trust. But now you can just make the election on your IRS form upon the point of passing, the first spouse passing.
Yeah. That has made, I think, estate planning a lot simpler in essence of being able to just make that election, which I'm glad you said that. It is important to know you have to file a 706 in order to make that election for portability. But that allows, the first spouse to transfer whatever their unused exemption is to the surviving spouse, which not always, but I think in many ways has reduced the effectiveness of the bypass trust. I think one case in which you could still consider a bypass trust, and interested in your feedback as well, but if you have a spouse who dies, maybe significantly prematurely, and they have, a significantly sized estate, you can file or you can elect portability, and it allows that unused exemption to flow from the first spouse to the surviving spouse. But if there's a lot of future growth on those assets over a long period of time, you could still end up in a situation where you have assets in excess of both unused exemptions, whereas the bypass trust, if it were utilized at the death of the first spouse, all the future growth on the assets that funded that trust would continue to be excluded from the estate at the death of the second spouse to die.
Right. I think that's a really, really important kind of exception to the rule. We have certain couples that meet those criteria. And I think that that's the exact reason that we would use a bypass trust. I think that if a person is kind of nearing that cap to where it would be a taxable estate, then go ahead and use the bypass trust so that the growth is not going to become an issue for the surviving spouse. The growth in the bypass trust doesn't become an issue for the spouse.
Yeah, absolutely. And too, as we've discussed with some of the other trusts, I think the ability to have a step up in basis is important as well.
Right.
If you elect portability, you continue to be able to step up. You get a step up in your cost basis at the death of the first spouse, and then another at the death of the second. Whereas the assets that flow into the bypass trust, if that were utilized, you don't benefit. While you benefit from the estate tax exclusion, there is no cost basis step up. So
That's right.
another factor I would say is important for consideration.
Great point, Grant.
Yeah. Thank you, Tori.